Welcome to the last in the Garden Court series on protest law, looking at then and now. It's been an incredible series looking at the development and changes in protest law from Newbury to XR, from Mangrove to Black Lives Matter and other issues. And those protests that have gone before us are still available on the Garden Court website, and there's going to be links posted in the chat feature in this webinar as well, and I commend them to everybody. I'd like to thank Danielle Manson and all of the speakers who've spoken on previous occasions for their fantastic and fascinating contributions. And those webinars have been looking at the history, where we have been events previously, and drawing lines and making connections to current protest movements. And this webinar, to round it off, is intended to look at where we are now in terms of the protest demonstration landscape, and to some extent look at what's next. And so where are we now, by way of an overview? Well, there is in Parliament a bill being voted on tonight that will be, if it's passed, perhaps the most draconian piece of anti-freedom of speech legislation that this country has seen, designed to silence protest, so oppressive that Vladimir Putin would probably think it's a bit much. Police are walking the streets, acting with violence and impunity, and the courts are mostly perhaps either unwilling to intervene or have taken steps to narrow or remove the defences available to protesters. And so where can we go next? What will happen next? The first and most important thing is that that bill must be thrown out, not amended, not reformed. It must be thrown out in its entirety, not just the sections in relation to protest, but those in relation to the extension of police powers, those that seek to demonise the traveller community. How will that happen? It will happen by fighting it in Parliament, through our elected representatives, fighting it in the courts, and fighting it in public with protest itself. It will happen if we unite all those groups who fight for freedom of speech and assembly on our behalf: XR, Reclaim the Streets, Black Lives Matter. It will happen by not allowing the government and the media to dictate the narrative of good and bad protesters. This bill poses an existential threat to all of us, anyone who believes in freedom of speech, and it must be stopped. Before we do that, we have to educate ourselves and others as to the current state of the law and the threats that this bill poses. And in order to do that, we're joined this evening by an expert panel. I'm delighted to be joined by all the co-authors of the Protest Handbook, myself and Owen Greenhall from Garden Court Chambers, Anna Morris from Garden Court North, Lochlinn Parker from ITN Solicitors, and even more delighted to be joined by Kevin Blowe from the Network for Police Monitoring. We're going to go through the most recent authorities, I think, just dealing with what's happened in 2021. It's been an extremely busy year, and we're only halfway through March. Owen and I will cover what's been going on in the High Court, the Court of Appeal, and touching on the Supreme Court. We'll then turn to policing and protest in a time of pandemic, which will be dealt with by Lochlinn. And then lastly, we're going to come to the bill. Anna Morris is going to outline the changes to existing protest law, the new offences that the bill will introduce. and set out what those are. And Kevin is then going to speak about those changes and what the effect of them will be. Just before I introduce Owen as our first speaker, there's a few technical matters. You've all been placed on mute. There will be a time for questions and answers at the end of the webinar, so please do post your questions in the Q&A window. You'll see at the bottom of the screen there's a feature for posting questions. The chat function is I think enabled for the comments, queries or feedback. The resources, the slides will be circulated to the registered delegates after the webinar. This webinar is being recorded, and so what that means is the audio and video of the panelists and anyone who speaks, if they're unmuted, will be recorded, and this webinar may be shared on our marketing channels, including our website and social media, so bear that in mind if you put any personal details in the Q&A. And please refer to the instructions, I think, which should be in the chat window if you're experiencing any technical difficulties. We've got a lot to get through this evening, so I'm going to kick straight off by introducing Owen Greenhall. As I've said, a fellow member of Garden Court Chambers, a specialist in all aspects of law relating to protest and freedom of expression, extensive experience of litigation in this area, both in criminal trials and civil claims relating to protests, including actions against the police and possession proceedings, as well as being a co-author of the Protest Handbook. He's also co-chair of the NETPOL Lawyers Group, which is the group of protest lawyers affiliated to the Network for Police Monitoring. So Owen is going to talk about recent events in the Court of Appeal and higher. Over to you, Owen.
Thank you very much, Tom. Given the recent events over the weekend and the matters before Parliament, I intend to be brief so that there's plenty of time for discussion. But I will talk very briefly about the Stansted 15 appeal. I will also talk a little bit about the Ziegler case, and then I want to just mention some older cases which underscore the importance of the right to freedom of expression, because I think it's very important to view the current proposals before Parliament in light of the history of the case law. It's important to remember that whilst the courts often assert the importance of the right to protest, there has in truth never been a golden age of where the right to protest has been protected. Those rights that we do have been very much hard-fought rights, and they should not be given up easily, and certainly we should not allow a government to take them away from us. Turning first to the Stansted 15 appeal, I will share my screen. And the case of Thacker and others, which was in the Court of Appeal last year, and we had judgment earlier this year, was the appeal arising from the Stansted 15 case. As many people know, it was a demonstration at an airport where activists prevented a deportation flight, which was taking people to West Africa. And they did so in order to prevent harm to those on board, particularly members of the LGBT community. The appeal was successful. There were 5 grounds of appeal. It was the first ground, the elements of the offence, which was the point on which the appeal turned. And it has to be said that credit has to be given to Blin and Negrawley at Matrix Chambers and Claire Montgomery at Queen's Counsel for the work that they did on that. But of particular importance in the protest sphere is the defence of necessity. And that is what I will focus on. But before I look at the details of that, I do want to emphasise that the impact of the Stansted 15 trial on the defendants should not be underestimated. The impact of a lengthy Crown Court trial and very lengthy appeal proceedings was something which of itself has a real impact, and it has to be remembered that at the end of the day, what they did prevented the deportation of 11 people who were at real risk of significant harm. So turning to the arguments in relation to necessity in the Stansted case, there was a lot of argument in the Court of Appeal on this point, but that is unfortunately not reflected in the judgment, which deals with the point quite shortly. There are effectively two key passages of the judgment. The first is a reference to the well-known passage in the case of the Crown and Jones, which is a previous House of Lords authority, and Lord Hoffman's comments at paragraph 94. What that says is that in a case in which a defence requires that the acts of a defendant should in all the circumstances have been reasonable, his acts must be considered in the context of a functioning state in which legal disputes can be peacefully submitted to the court, and disputes about what should be law or government policy can be submitted to the arbitrament of the democratic process. And he goes on to say, in such circumstances, the apprehension, however honest or reasonable, of acts which are thought unlawful or contrary to public interest cannot justify the commission of criminal acts, and the issue of justification should be withdrawn from the jury. Those comments has always posed the most significant obstacle to anyone seeking to put forward a necessity defence in a protest case. And what the Court of Appeal in Thacker said was that they endorsed those passages. They said they weren't in fact limited to the defence of prevention of crime, but they were of general application to necessity and other defences of justification. And they weren't simply obiter comments, they formed part of the ratio of the decision. That was one aspect of the judgment. The other aspect of the judgment was an endorsement of the factual findings of the trial judge in relation to what the trial judge believed or held the defendants to be doing. So the Court of Appeal said that the trial judge was right to characterise the appellant's conduct as direct action, and states that the appellant's real reason for halting the flight was because they believe all removals and deportations are illegal in the sense they choose to use the term. This was the appellants taking the law into their own hands, and the trial judge was right to withdraw the defence from the jury. There are two ways to understand the judgment. The first is effectively a policy argument, to understand that the Court of Appeal is saying that as a matter of public policy, defences of necessity and other justification defences can never be allowed to be left to a jury in a protest case. Now, to say that that is a policy argument endorsed from the House of Lords and binding on the Court of Appeal effectively removes any form of argument before the courts. There's not much that can be said. It's not determined on principle. It's simply stated as policy. The other way to understand the argument is that direct action cases should still be decided on general principles of criminal law. That's why it was important for the Court of Appeal to look at what the trial judge said about the appellant's motivations. The trial judge made a determination that in fact they weren't acting to save lives, that they were protesting, and it was that which was the basis for ruling the defence out. The question, therefore, then follows is, well, what is the statement about the comments of Lord Hoffman? And effectively, what the Court of Appeal are saying is determine defences of justification in direct action cases on general principles of criminal law, but do not extend those principles in any way to encompass direct action cases. So if on general principles the defence is available, then it's left to the jury, but there is no room to bend the rules in favour of defendants in direct action cases. That, of course, has much more to commend it by way of principle behind it, It doesn't simply put direct action cases in a special category. It simply keeps the defences of necessity within strict limits. Now, how the courts will go on to interpret the ruling in the Court of Appeal here on in remains to be seen. There are, of course, a number of cases coming through the courts which raise these issues. The next case that I want to talk about is the case of DPP and Ziegler. This was decided in the High Court in 2019, and argument was heard in the Supreme Court on the 12th of January this year. We are still awaiting judgment when this, and given that the case is still live, I'm not going to say very much about it at all, but I just want to highlight that most of the argument in the Supreme Court turned on the correct test that an appellant court should take to a finding of proportionality made by a lower court, and that's a technical legal point. What I think is important to look at are the comments that the High Court made about the importance of the right to protest, because the High Court underscored the importance of freedom of expression in the following terms. It stated that freedom of expression is important for the autonomy of the individual, and it extends beyond political speech in classical definition, but it includes ideas that may well shock the majority of the public. It applies to not just the mainstream views, but minority views as well. It also went on to say that it is freedom of speech is conducive to the discovery of truth. It's important to be able to share ideas in order to develop ideas. And then it went on to say freedom of speech is essential to the proper functioning of a democratic society, to allow access to different points of view and to information. And importantly, that it helps maintain social peace by permitting people a safety valve to let off steam. In this way, the High Court said it was hoped that peaceful and orderly change will take place in a democratic society and reducing the risk of violence and disorder. Now, that last comment is a reference to comments in the 1999 case of Ex parte Sims, which is a prisoner case, where in fact the House of Lords went somewhat further. What the House of Lords said there is freedom of speech is the lifeblood of democracy. The free flow of information and ideas informs political debate. It's a safety valve. People are more ready to accept decisions that go against them if they can, in principle, seek to influence them. It also says freedom of speech acts as a brake on the abuse of power by public officials. It facilitates the exposures of errors in the governance and administration of justice of the country. That comment also is reflected in the well-known case of Redmond Bate and the Director of Public Prosecution, where Lord Justice Sedley said that freedom of speech includes not only the inoffensive, but the irritating, the contentious, the eccentric, the heretical, the unwelcome, and the provocative, provided it does not tend to provoke violence. He went on to say what Speaker's Corner, where the law applies as fully as anywhere else, demonstrates is the tolerance which must be extended by the law to opinion of every kind, and expected by the law to the conduct of those who disagree, even strongly, with what they hear. From the condemnation of Socrates to the persecution of modern writers and journalists, our world has seen too many examples of state control of unofficial ideas. A central purpose of the European Convention of Human Rights was to set close limits on any such assumed power, and we in this country continue to owe a debt to the jury, which in 1670 refused to convict the Quakers William Penn and William Mead for preaching ideas which offended against state orthodoxy. That is a reference to the case of Penn and Mead, which is the foundation for the basis on which no judge can direct a jury to convict anyone in a jury trial. That is matter of fundamental importance when it comes to the assessment of what the public see as reasonable conduct within the criminal sphere, and is one of the key principles underlining defences of justification and when they should be left to the jury or not. So this history, these case law, it is, in my submission, what we should view the recent attempts to restrict the right to protest. And when we're looking at the bill that's currently before Parliament, it's important to remember that some of these activities, there have already been attempts to prohibit and restrict a number of these things. There have been attempts to use bylaws and secondary legislation to restrict the right to protest. If we look at the case of Tabernacle and Secretary of State for Defence, which was a case where the Secretary of State sought to use bylaws to prohibit camping and effectively to bring the Aldermaston Women's Peace Camp to an end. And the bylaws were passed prohibiting the following acts: camping in tents, caravans, trees, or otherwise; attaching anything or place anything over any fence, structure, or other surface; or to act in any way likely to cause annoyance, nuisance, injury to other persons. Now, the High Court struck out G, attaching anything or place to any structure. The case went to the Court of Appeal in relation to F, the prohibition on camping. The J, the clause relating to causing annoyance, was in fact not litigated, but it was very much in the back of the court's mind. And Lord Justice Laws went on to make the following comments in his judgment: rights worth having are unruly things. Demonstrations and protests are liable to be a nuisance. They are liable to be inconvenient and tiresome, or at least perceived as such by others who are out of sympathy with them. Whether or not the Aldermaston Women's Peace Camp's cause is wrong-headed and misconceived is neither here nor there. And if the activities are inconvenient or tiresome, the Secretary of State's shoulders are surely broad enough to cope. Looking at recent events and matters before Parliament, it would appear that we currently have a Secretary of State who lacks the broad shoulders to tolerate protests, who lacks the broad shoulders to tolerate ideas which go against what the government would see as the right way to behave. And when those sorts of considerations have come before the courts before, we've seen how they should be dealt with. And in my submission, this case law is what we should be looking at when we think about how to respond to the matters that are currently before Parliament. So, in order to leave time for everyone else to speak, that's all I'm going to say. Thank you.
Thank you very much, Owen. I can see we're getting some questions. We're going to leave them all to the end. I think one thing to consider, although Owen struck a hopeful note at the end about these matters being struck out, is the current composition of the Supreme Court and the other higher courts, which are very different now to the composition at the start of this millennium, when some of those more positive judgments were passed. And that is something that we will have to bear in mind and certainly can't take for granted. So it's now my turn. I'm going to deal with two cases which have been in the High Court recently this year. One that I was in myself, and one that our colleague at Garden Court, Audrey Mogan, was in, and both concerning the rights to protest. There was going to be a third. There's been another High Court case at the start of January, but it hasn't yet been published. And apparently, I heard the other day when the CPS phoned up to ask about what was happening to it, the High Court said they weren't planning to publish it. As it's not a particularly helpful case for the defence, I'm not going to push them to publish it. And I'm not going to discuss it here either. So I'm going to discuss the ones which either have had judgment published or are helpful, and those should be coming up now if I share my screen. So the two cases are Neil and the DPP and Halcrow and CPS. And I'm going to start with Neil and DPP. This has had a bit of attention online after we published the summary of the outcome. And I think it's going to be helpful to clarify what it does deal with, what it says, and what it doesn't say. So this was a case which concerned the coronavirus regulations as they were at some particular point last year and as they applied in Wales. So it's very specific but in terms of time and place. The essential facts were the appellant was out in public. He was asked by two PCSOs why he was out in public and told that he had to give a reason, and he declined to do so. The PCSOs asked for assistance. Two police officers attended the scene. The police officer then again spoke with the applicant, asked for his name and address, and he refused. And the reason the officer had asked for his name and address was so that a fixed penalty notice could be issued for breach of the regulations. This is the summary taken from the case stated. He refused and was arrested and taken to the police station, where they ultimately determined his name and he was bailed to attend court. He was charged with breach of the coronavirus regulations for being out without a reasonable excuse, and secondly with obstructing a police officer. And the obstruction specifically was failing to provide his name and address to the police officer. The ultimate decision was by the magistrates was that he was, after trial, acquitted of breaching the coronavirus regulations. And it's worth just pausing to deal with that because his reasonable excuse was both that he was homeless and also that he was taking a key worker's car to be repaired. And the magistrates accepted that was what he was doing, and it was correct that he was homeless and that amounted to a reasonable excuse. Being homeless is automatically, or certainly was under the previous regulations, a reason to be away from home, obviously. And it wasn't right, as the police officers had told him, that he had to give a reason as to why he was out in public or explain anything to them. The consequences of it was that it may be less likely that he would be believed at trial because he didn't give that explanation at the time, not through a formal adverse inference, but something the magistrates would be entitled to take into account. But ultimately, it's not a bar to being acquitted. And it was an example of the police officers misstating their powers, which we've seen a number of examples of in relation to these regulations. But he was convicted of obstructing the police officer for failing to give his name and address. And that decision was appealed by way of case stated to the High Court. The reasons the magistrates gave were that the purpose of the legislation would be defeated if the applicant were permitted to avoid the issuing of a fixed penalty by refusing to provide his name and address, and stated that because this was an exceptional time of pandemic, that one has to respond when police request your name and address, otherwise the regulations would be of no use and would be inoperable. And it was implicit that he had to provide those details. Now, the case which I'd cited to the magistrates at the time and formed the backbone of the appeal was the well-known case of Rice and Connolly, dating back all the way to 1966, in which the Queen's Bench division held that it was quite clear that although every citizen has a moral or, if you like, a social duty to assist the police, there is no legal duty to that effect. And indeed, the whole basis of the common law is the right of the individual to refuse to answer questions put to him by persons in authority. There's further authority in support of that. I won't go through all of these slides in detail. They'll be available afterwards. And so the grounds of appeal were, firstly, that Rice and Connolly set out that for something to be willful obstruction, it has to be done without lawful excuse. There's no duty to provide details unless one can be found in the legislation or implied. There's nothing in the legislation in those circumstances. There are other examples where it's been made specifically an offence not to provide details, and there's examples there. And Article 8 comes into play. Importantly, the right to a private and family life and providing personal details to the state is covered by Article 8, and this was emphasised most clearly in the case of Mengesha and the Commissioner of Police for the Metropolis, such that any obligation to provide those details had to be in accordance with the European Convention and in accordance with the law. And bearing all of that in mind, the argument was there was no legal duty and one should not be implied. The court's decision was that they accepted all of those submissions. Mr. Neal was not legally obliged to give his details. His refusal was not willful, and therefore he was not guilty of willful obstruction. A few quotes from the judgment, from my notes of it, say the final judgment isn't out yet, but the right to remain silent is not reserved only for those who are innocent and beyond suspicion. The magistrates had suggested because he was out in prima facie breach of the regulations, that somehow meant that Rice and Connolly didn't apply. And very helpfully, the High Court have held that courts should be wary of expanding police powers by implication. Now, what Neal and DPP does not say, or what should be borne in mind, is that one of the reasons why the High Court agreed these regulations were not rendered inoperable if a person refused to give their details was because if they refused to give their details for a fixed penalty notice to be issued, they could be arrested, as indeed happened in this case. And the police have that power under Section 24 of the Police and Criminal Evidence Act if they have otherwise got grounds to suspect someone of committing or having committed or being about to commit an offence. They can arrest them in order to establish those details. And also, it was important in that case that it was the police officer who'd asked for the details, because there are powers for police community support officers who don't have the power of arrest to require someone to give their name and address in certain circumstances. It's not entirely clear whether or not those circumstances, here as it's referred to a relevant offence, includes breach of the regulations. It's a bit of a rabbit hole to go down to try and untangle what powers the police community support officers have. But it depends on whether the offence is a relevant offence. A relevant offence is defined there. I'm not going to go into it here. It depends on whether or not it's part of the police community support officer's designation or is listed elsewhere in the Police Reform Act, whether it falls into that category or whether it falls into some other category of offence. So those caveats have to be borne in mind. Moving on to the other case, to talk about Halcrow and the CPS, which was the case which Audrey and I think also Timmy and Mac in Chambers dealt with quite recently in the High Court. It was a case concerning the Stonehenge regulations of 1997, which we're all familiar with. Regulation 3 prevented people without reasonable excuse entering or being upon any part of the site of the monument, which access is at any time restricted by barrier or prohibited by notice. And although, not to spoil the ending, the result didn't go the appellant's way, the analysis that the court carried out is in some ways helpful and reinforcing how these things should be looked at and analysed in the framework of the European Convention, because they argued that their rights under Articles 9, 10 and 11 were engaged, which was accepted. And the court agreed that if those had been impermissibly interfered with, then that would amount to a reasonable excuse for accessing the stone circle, which would otherwise be in breach of the regulations. And those applicants were there to practice their religion, which is why Article 9 was engaged, and to protest against the management of the site by English heritage. And they also agreed that it was the prosecution who had the burden of justifying the interference with those rights, and the court had to focus on the evidence that had been adduced and relied on by the prosecution. Otherwise, they could not have undertaken a close and penetrating analysis of the factual justification, as they're required to do. And if you can't see what the justification is, you can determine whether or not it's justified and proportionate. And the argument which had been put forward was that essentially the prosecution hadn't called any evidence, hadn't called anyone from English heritage to explain why, in these particular circumstances, these appellants were not allowed. There are occasions when people are allowed access to Stonehenge on particular days or in return for a fee or in other circumstances, which the appellants argued they were unable to comply with or take advantage of, and so this was the only option available to them. But ultimately it was dismissed. The court found that even on the very general admissions, really just relating to the nature of the site and the information about those other days when people can gain access, that was enough for the prosecution to discharge the burden on them. Otherwise, it would have meant that essentially the regulation would have been rendered inoperable, and they relied on the adverse effect on Stonehenge and found that the interference was justifiable and proportionate. So those are the authorities that I'm just wanted to share with everyone. I'm going to stop sharing my screen, and now I'm going to introduce Lochlinn, who's going to speak next. Lochlinn Parker is Head of Civil Liberties at ITN Solicitors. He has extensive expertise in taking legal action against the police and other detaining authorities, and specifically relating to public order and protest, working with organisations and individuals seeking accountability and compensation for wrongdoing or who want to challenge the decisions of state bodies. He advises campaign groups and NGOs, assists in devising legal strategies to further their aims, actively involved in campaigning organisations, including NETPOL. He's a member of the Police Action Lawyers Group, the Inquest Lawyers Group, and the Haldane Society, and as I've mentioned, a co-author of the second edition of the Protest Handbook. And so I'll hand over to Lochlinn.
Thank you, Tom. I will endeavour to just share my screen, hopefully, and then can get going. So in terms of what I'm going to talk about, I'm going to very kind of narrowly talk about sort of the right to protest in terms of getting out there on the street. Tom has covered issues in relation to sort of some of the things that come up in terms of fixed penalty notices and so on and so forth. And there's a lot to discuss about the bill, which obviously we've been touched on a number of times. So I'm going to be hopefully relatively brief and to the point. And primarily, it'd be good if we can get some questions to try and make some kind of discussion as far as that is possible in this medium. So hopefully we can get some interesting thoughts going. So just to give the overview, so the current version of the regulations is a health protection coronavirus restrictions all tiers England regulations 2020. All of England is in tier 4. There are provisions potentially for other tiers within the regulations, but at the moment everybody's in tier 4. You need a reasonable excuse to leave the house. I think we all sort of fairly aware of this, and there is a list of exempted reasons or good excuses to leave. If you don't have a reasonable excuse, then the police can give you a direction to return home. That's in Regulation 9(2)A. Though any sort of interaction they have with you, whether it's a direction or otherwise, has to be necessary and proportionate to the aim of preventing transmission of the virus, stopping you doing something that you shouldn't be doing. So if you are heading home already, then there is no issue. You shouldn't be given a formal direction. You certainly shouldn't be given a penalty notice. However, there is an offence, either of contravening the regulation or of ignoring the direction, there in Regulation 10, and of obstructing an officer in those circumstances. Fixed penalty notices begins at £200, but you pay it within 14 days is £100, and that multiplies every time you get a fixed penalty notice up to £6,400. So you need a reasonable excuse to leave the house. Furthermore, you cannot take part in gatherings outside of over 2 people unless that gathering is exempt. That's in Schedule 3A(4). The provision on inside gatherings, which I'm not going to touch on, is in 3A(3). And again, the consequence of being in a gathering that's not exempt, an officer can provide you with a direction to disperse in Regulation 9(3)A, and can use force to remove you in 9(3)A(C) and 4. That force has to be reasonable, etc. There is an offence, which mirrors the same kind of, which mirrors the same issues as in reasonable excuse. And then the fixed penalty notice is larger. It starts at £400. Well, it's 800, but 400 if you pay within 14 days. Again, multiplying for every infraction, as it were. And then lastly, you're not able to organise non-exempted gatherings outside of over 2 people, and then large gatherings are over 30 people, unless exempt. And that's regulation in Schedule 3A, paragraph 5. Now, in this particular case, there is no direction to disperse issue. If the police believe you're an organizer of a non-exempt gathering, then they can sort of automatically either arrest you or seek to issue you with a fixed penalty notice, and it's £10,000. There's no up or down on that. And as ever in these things, if you are going to seek to contest a fixed penalty notice, then your remedy is in the magistrate's court, which is not exactly ideal. But then again, I saw today, just before the meeting, somebody had tweeted that a person who'd organised a house party, a young person, had just, although sort of convicted of it, wasn't ordered to pay a fine, as the courts didn't consider it reasonable in those circumstances. So you can take your chances, but the magistrate's court is not exactly ideal given their conviction rate. So what you will notice in all these things is that protest is not specifically a reasonable excuse or in an exempt gathering, although it was in different versions of the regulations before and in different ways. Previously, it was specifically an exempted, protest was specifically exempted, and prior to that, it was more wordy, but essentially gatherings organised by political organisations could occur as long as there were the health and safety provisions, etc. So that's the overview. However, although protest isn't specifically exempted, the point in law here is that the regulations are secondary legislation. So they are, as it were, trumped by statute, and that's the Human Rights Act. And protest also has not been specifically banned by the regulations or any other provision. So hasn't been ousted by anything. It still exists there in the background. And then on top of that, case of Dolan, Secretary of State for Health and Social Care, which was in autumn last year. It was an anti-lockdown case, which in one part of it, it accepted that the regulations engage your convention rights, i.e. your rights to protest. So your rights to protest under Article 10 and 11 of the ECHR, as protected by the Human Rights Act, have to be read into the regulations. And for the non-lawyers on the stream, so read into means the police or any other authority has to consider their obligations under the Human Rights Act and how that matches up to what the regulations are also asking them to do, and then need to act in a way which is compliant with the Human Rights Act because it is sort of superior, as it were, to the regulations. So in what that means on the ground is that the police should only be taking necessary and proportionate action. Sorry, I missed that last bit of my previous paragraph. Of course, Article 10 and 11 are qualified rights, meaning that there can be interference with them, but that interference has to be necessary and proportionate in pursuit of a democratic aim, etc. So only necessary and proportionate action can be taken by the police, and they have to do that in fulfilling their duty to facilitate protest. And that's quite important. And so that leads us onto the Reclaim These Streets case, which, as I'm sure everybody knows, happened on Friday afternoon in a great rush, as it had to, in the High Court. And this is one of those cases which really shouldn't need to be brought in the first place. And in one sense, it's a very important case, but it doesn't do something earth-shattering, because actually what it does is tell the police what they should have known in the first place, which is that, it's annoying more than anything else that it had to be brought, but at least it has clarified things to a certain extent. So the claimants were seeking to get the court to rule that insofar as it prohibits outdoor gatherings, the regulations, the right to protest is there within the regulations, and that the Met Police's policy of prohibiting all protest, regardless of the circumstances, would be therefore unlawful. And of course, the people who are exercising their right to protest in a reasonable manner have a reasonable excuse and are therefore able to leave the house, and gatherings can take place, you can organise them, etc. The court sort of didn't bite on all those things, but nevertheless did clarify issues. I should say, obviously, that the Met Police had previously indicated, and certainly that was their practice on the ground, that protest, because it wasn't exempted, protest was unlawful, and they'd said as much in tweets and so on and so forth, particularly in the late autumn. And this apparently is in Operation Pima. I see that somebody's done an FOI to look for that. And so hopefully that will see the light of day outside of litigation as well. And they then sort of went back on it, of course, because they had to, and said, of course, that's wrong. But the circumstances here mean that protest couldn't go ahead. And part of the problem here is it wasn't really just the Met Police who were confused, if we want to be charitable, about what the law was saying. a couple of weeks ago, there was a joint select committee on human rights, I should say, evidence session on protest and on other issues like fixed penalty notices and so on and so forth. And there, Chief Constable B.J. Harrington, who's the National Police Chiefs Council Public Order Lead, in answer to a question from Joanna Cherry about whether or not there was a right to protest under these regulations, replied saying absolutely there was, it existed. Accepted they had to be balanced, but it existed. Now, he said that a couple of weeks ago, and then we had reporting in The Guardian on Friday, I think it was, possibly, where the NPCC were giving out guidance to police forces saying that, vigils couldn't go ahead. And so they've all been very confused by this. And to be honest, rather unreasonably, because it is relatively straightforward, as the court itself decided. Protest is not illegal per se under the regulations. Police have to consider the rights under the ECHR, Article 10, urban rights to protest, and that protesting could be a reasonable excuse. And then said, these, and that quote at the bottom sort of sums that up, but I kind of taking a particular point out of it is that every case has to be considered on the circumstances, and that's really the most important thing. However, that leads into all kinds of sort of problems. The police, the Met Police at least, in pre-action correspondence in August, when I was doing a case for somebody who wanted to do a Black Lives Matter protest, accepted that they were not the experts in terms of health and safety. They're not. They're potentially the experts in public order, but they're certainly not people who understand the transmission of a virus and what public health considerations need to be made. And so for this period kind of between August and December, the police were outsourcing that decision about what was a compliant protest to the local health and safety department of a local council. But here we have a situation where the police are still trying to decide what is a health and safety concern and what's not, based on what can be no more than common sense, because they're not experts in doing so. So although there is, any blanket policy banning protests would be unlawful, it's really unclear as to when the police are going to be able to intervene lawfully, at least. I mean, as we saw on Saturday night, they're going to intervene almost certainly in most circumstances, or at least be seeking to dissuade people and to disperse people and threaten to find them, which of course is problematic in terms of the chilling effect that has on people's right to protest. But there really is a big grey area about it. Now, a protest group can take steps to try and fend off police action by taking steps to consider the public health issues, potentially having a health and safety risk assessment as the previous versions of the regulations required, and also kind of considering, how big this protest is going to be and what form it's going to take. But those things are also very difficult to control, even for relatively well-resourced organisations, and particularly at times of sort of emergency or pressing issue like we have at this week. There are back to back, and there's going to be another protest later on this evening. Trying to control that and who comes and who doesn't is extremely difficult. But as we slowly step out of lockdown, the stay-at-home order ends on the 29th of March. 12th of March has us possibly outside pubs. The 17th of May we're allowed to be in people's houses, etc. As that steps out towards June the 21st, the ability of the police to place restrictions on protests will get less. And so your right to protest uninterfered with will increase as time goes on. And this is a point David Mead made, and I think he's listening on, so hopefully I won't get him, I won't misquote him, but the primary question for police forces is not whether anyone is breaking the law, but how can they exercise or fulfill their duty to facilitate a peaceful protest. That should be their starting point. It hasn't been, and it may not be, but that's where they really should be looking at. And hopefully, if you are engaging with the police in advance, you should be pushing that as the primary question for them to be answering. And we'll see how that all plays out. So that's all that I have. A bit of a whistle-stop tour, but if there are questions, please do put them in the Q&A, and we'll do our best to answer them. Okay, I'm going to stop sharing. Okay. Tom?
Thanks, Lochlinn. Speaking of the Q&A, David Mead, who you mentioned, has popped a question in there. So, Lochlinn, I don't know if you want to answer that while we move on to Anna Morris, who's going to be outlining the main provisions. It's impossible to, I think, cover all of them in the time available. And I think we could easily spend a whole session dissecting one particular or two particular sections and how awful they are. And I think they are almost entirely awful. But Anna's going to do her best to outline the key ones, perhaps the most worrying ones. Anna is a barrister at Garden Court North Chambers, specialising in inquests, inquiries, civil liberties, human rights, and private and public law claims involving public authorities. She's a recognised leading junior in Chambers of Partners and Legal 500, acting with a particular expertise in the law relating to policing protests, public order, deaths in custody, and often instructed in large-scale, complex, multi-agency cases. She's, as well as co-authoring the Protest Handbook, an editor of Stone's Justice's Manual, and specialises in claims which relate to incursions on the right to freedom of assembly and freedom of speech, having successfully represented groups or members of groups such as Occupy Democracy, Critical Mass, and some of the anti-fracking movements. So, Anna, if I can hand over to you, please.
Thank you, Tom. Good evening, everybody. Hopefully you'll be able to see my slides. I have the unenviable task of taking you through the main key provisions of the bill, and I'm going to try and do so as succinctly as possible, because many of you will already be familiar with the key provisions, having familiarised yourself with the press reports and the many summaries that are out there. I'm going to deal with the key proposals that the relevant sections as they pertain to protest law detail, and I'm going to deal with some of the background, and then I'm going to deal with some of the new offences, some of the amended offences. First question we need to ask ourselves is, why did this bill come into being? Why did the Secretary of State, with her broad shoulders, think that additional measures were necessary? Well, instructively, we can look to the bill's own fact sheet, and it quotes Cressida Dick as saying, ever since the first large-scale Extinction Rebellion protest in April last year, I've been talking publicly with the government about the potential to change powers and the legislation that would enable the police to be able to deal better with protests in general, given the act we do, the Public Order Act, 1986, is now very old. But specifically, she says this, to deal with protests where people are not primarily violent or disorderly, but as in this instance, had what she termed an avowed intent to bring policing to its knees and the city to a halt, and were prepared to use the methods we all know they did to do that. The important two words there, I suggest, are not primarily violent or seriously disorderly. So when we're looking at the provisions that the bill makes, we need to be asking ourselves, what criteria are those powers applying to protests? Is it serious disorder, or is it something less than that? And you'll see as we go through that the requirements for there to be serious disorder have reduced in terms of the ability of the police to impose conditions on both processions and static assemblies. So why do the government say these measures are needed? And again, this comes from the government's own fact sheet about the bill. It feels that the Public Order Act 1986 is no longer fit for managing the types of protests we experience today, and what the government termed as the highly disruptive tactics used by some protesters cause a disproportionate impact on the surrounding communities and are a drain of public funds. And then it quotes the amount the Metropolitan Police spent, it says, on policing the Extinction Rebellion protest in 2019. What, in fact, you and those who've attended these webinars over the previous weeks and months have heard is a chronology, a history of protest and demonstration that started before 1986, that has been going on since 1986. And when one looks at the background and whether, in fact, the Public Order Act 1986 is, in fact, fit for purpose, it's important to scrutinise that history, that background of political protest, and the court decisions that Tom, Owen and Lochlinn have just taken you through when assessing when, in fact, it was necessary, whether there are increase in what she terms high disruptive tactics, or whether there are good reasons for passing a bill with increased restrictions and decreased levels for criminality. So the first thing I'm going to talk about is the new provision that amends the criminal damage offences. Now, at the moment, criminal damage is triable either way, but is only triable in the Crown Court if the value of the damage exceeds £5,000. That will change if this bill becomes law, and it will become a triable either way offence, even if the value of the damage is less than £5,000, if the following conditions are in place. And I've put in red the new or amended provisions, so you can see how the law has changed. So criminal damage can now be a triable either way offence, even if the value is less than £5,000, if the damage that's caused is to a memorial. And that's defined here very broadly as a structure or any other thing erected or installed on land or in a building, or any garden, any other thing planted or grown on land with a commemorative purpose, including any movable object. A bunch of flowers is given as the statutory example that's left in or on a memorial, and has or can reasonably be assumed to have a commemorative purpose, also to be regarded as a memorial. What's not stated is whether the person who is said to be committing the criminal damage knows that it is a memorial, or knows that the items are being used for a commemorative purpose. Commemorative purpose is set out in the bill as having the purposes of including the commemoration of individuals or animals or a series of events. And it says it's immaterial whether or not individuals or animals are concerned, or are living or deceased, or capable of being identified. So that's a change, a big change to the criminal damage provisions. A new offence. We all can understand the reaction of the government to the protests in Bristol and elsewhere. That is clearly what this is intended to respond to. And the point to highlight is that criminal damage, the statutory maximum on indictment is 10 years. So triable either way offence for a value under £5,000 now will also attract a maximum of 10 years imprisonment on indictment. So that is a clear message the government wants to send to protesters, a heavy message, which is a radical change on the criminal damage provisions and a radical change of the mode of trial of criminal damage provisions. I'm going to move next to deal with the amendments to the Public Order Act itself. And again, you'll see in a moment, I've put the new text in red, and you'll get a copy of these slides and you can see and read it in your own time exactly what's been added. But just to give you the headlines, so the amendments the bill makes to the Public Order Act is that it introduces into Section 12, which deals with conditions that can be imposed on processions, and Section 14, which deals with conditions that can be imposed on assemblies, the ability to impose conditions where there is a risk that noise will cause serious disruptions. That is an addition and a change to the situations in which conditions can be imposed on either processions and or assemblies. The bill brings Section 14 in line with Section 12, in that if certain statutory criteria are fulfilled, a senior police officer can give directions imposing upon the persons who are taking part in a procession or now an assembly such conditions as appear to him necessary to prevent such disorder, damage, disruption, impact, or intimidation. Before, the provisions were slightly different for a procession and for an assembly. They are now elided so that a senior police officer can give directions to both for the same reason. And thirdly, the amendments change the mental element, the mens rea of the offence of breaching those conditions. And I'll deal with each of these aspects in turn. So these are the granular parts of the changes that Section 54 and 56 of the bill make to Section 12 and 14 of the Public Order Act. Again, text in red is the new inserted text. Text in black is the existing law. I've put them together so that you can see that now Section 12 and Section 14 are more similar, but just taking you through it. Now, under the bill, if it becomes law, a senior police officer, if he or she determines that a procession or assembly is being held that may result in serious public disorder, damage to property, or serious disruption to the life of the community, then the procession or assembly and then has noise that's been generated by persons taking place in the procession may cause serious disruption to the activities of an organisation which are carried out in the vicinity. So that's the new part. Previously, the senior officer just had to conclude that the procession or assembly would result in serious public disorder, serious damage to property, or serious disruption. Now he or she can impose conditions where he or she is satisfied that the noise generated by people may create serious disruption to the activities of an organisation which is nearby. So that's a significant change. So in the case of a procession or assembly, the noise generated may have a relevant impact on people nearby, and that impact must be significant. So not just what people are doing, where they are going, but the noise they are generating is now something that a senior police officer can take into consideration in terms of deciding whether to impose conditions on either a procession or an assembly. And if those criteria he or she feels are fulfilled, they may give directions to people taking place in either a procession or an assembly as he or she feels fit is necessary, importantly, to prevent such disorder, damage, disruption, intimidation, or impact. And that now applies to both processions and assemblies. Dealing with the noise provisions, it sets out what noise impact may look like. It says noise generated by persons taking part in a public procession may have an impact on people nearby if it may result in the intimidation or harassment of persons of reasonable firmness with the characteristics of persons likely to be in the vicinity, or, and this is a significant addition, it may cause such persons to suffer serious unease. Now, I've put that in bold, alarm or distress. So we have here a new concept of serious unease, hitherto not in the Public Order Act. Where is the definition of serious unease? It's not within the legislation. And when we have already looked tonight at some of the case law that Owen has cited, some of the Supreme Court, the Court of Appeal case law that makes it very clear that the right to protest is a right which can be enjoyed and can cause inconvenience, it can cause offence, it can cause it is an expression of things which may make people feel uncomfortable. It is of significant concern to see the phrase serious unease in a piece of legislation regarding the conditions that can be imposed on protest. So it goes on to detail some of the conditions that can be imposed in respect of noise, in terms of the duration and the intensity of the impact it's going to have on people. But this is, again, an addition which is of significant change. The Secretary of State may, by regulations, again, that's my bold, make provisions about the meanings of some of this statutory language, the meaning of serious disruption to the activities of an organisation which is carried on near a public procession, or serious disruption to the life of the community. So what it means by regulations is the Secretary of State can pass a statutory instrument, so lay before Parliament a statutory instrument explaining what, in her view, serious disruption to the activities of an organisation or serious disruption to the life of the community is. But that regulation does not have to be voted on by members of Parliament. So it is a matter for the Secretary of State to define those concepts, and they can be defined once. They can be defined by a second set of regulations, a third set of regulations, neither of which or none of which will have to be approved by the Houses of Parliament. So that is a significant additional power given by the Secretary of State to make those definitions of law. And it goes on to describe what those regulations can contain. I'll move on now to the amendments in terms of the offences that are under section 12 and 14. And these apply both to organisers and participants. And I've put there which sections deal with which. So at the moment, as things stand now, a person is guilty of an offence of not complying with a condition if they knew about the condition and knowingly failed to comply with it. Under the bill, and if it becomes law, that will change, and a person will be guilty of an offence if they knew or ought to have known the conditions that were imposed. I've again put that in bold to highlight the significance and to highlight the change. So one can think of examples where conditions are communicated by leaflet. Maybe they're provided by an officer in a large gathering. There may be 15 to 20 people between that officer and the other side of the demonstration. But when we look at the reasons that were given as to why this additional mental element, which is essentially a lowering of the mens rea for the criminality of these offences, was changed, the bill fact sheet says this measure will close a loophole which some protesters exploit. Some will cover their ears and tear up written conditions handed to them by the police so that they can evade conviction for breaching conditions. On a protest, as a prosecution, they'll have to prove that person knowingly failed to comply with a condition. The bill will change the threshold, and I've explained how it lowers the threshold for the offence that it's committed where a person knows or ought to have known a condition has been imposed. So it's explicit. The government isn't shying away from it. It's explicit what they are trying to criminalise and how they are trying to criminalise an increased number of individuals who attend a demonstration or a procession. They also have increased the sentences in this bill for the offences under section 12 and section 14. The sentencing or the maximum sentence for an organiser goes up from 3 to 6 months, so doubles, and the maximum sentence increase for a participant again doubles from a £1,000 fine to a £2,500 fine. So it is quite clear the government's intention as to how they wish these offences to be perceived in terms of seriousness and the impact that is intended to have upon individuals' decisions as to whether engage in lawful protest. I'm going to move on quickly now, I'm just mindful of the time, to some of the other, to the new additions. Section 60 of the bill creates a new offence, a new set of conditions for that can be posed on one-person protests. And you can see an entirely new set of provisions there, 14ZA, highly quotable, where a senior police officer can impose conditions on a one-person protest in England and Wales. Again, it contains that noise provision is a reason why conditions can be imposed, similar to the Section 12 and Section 14 offences. It defines a one-person protest there. The maximum sentence for failing to comply with a condition imposed on a one-person protest is a £2,500 fine. Again, it's new or ought to have known. And I just put a note there. It is a level 4 fine if on a conviction for failing to comply with a condition imposed on a one-person protest. But if you are convicted of inciting someone to engage in a one-person protest, that is a maximum sentence of 51 weeks imprisonment and a level 4 fine. Moving on then to some further amendments. Many of you will be familiar with the Police Reform and Social Responsibility Act 2011, which deals with restrictions around Parliament Square and areas around Westminster. This adds areas that are classed as controlled areas for the Palace of Westminster, and I put those in red: Cannon Row, Parliament Street and Derby Gate. It also expands the definition of controlled areas, not just to the highways, but any land immediately adjoining the highway to which the public have or permitted access. So if Parliament Square was not already included, it would be by this definition, and any other land adjoining the highway will now be included as a controlled area of the Palace of Westminster. Prohibited activities, Section 143 of the 2011 Act, it's now got an extra element to it of obstructing the passage of any vehicle of any description along that highway in and out of the parliamentary estate within that broadened area. The intent, what is sought to be captured here is obstructing vehicles in and out of the parliamentary estate. But again, that area has been broadened. It includes the area next to the highway, so a significant change there. Nearly finally, but no less significantly, Section 59 of the bill puts the until now common law offence of public nuisance onto a statutory footing. Now, this has been something which has been under discussion by the Law Commission for a number of years. They issued a paper in 2015 which made recommendations that the common law offence of public nuisance should be put onto a statutory footing. Public nuisance has been the subject of a number of prosecutions of those engaged in peaceful protest over the years. The common law offence is indictable only. Maximum sentence as a common law offence is life imprisonment. It is now, if the bill passes, going to be a tribal either way offence, so it can be dealt with either in the Magistrates' Court or in the Crown Court, with a maximum sentence of 10 years. So one may think some improvements there. The concern is that the case law, which over time developed the principles around public nuisance, on each occasion where it involved peaceful protest, made it very clear that balancing act that Owen touched upon between the engagement of lawful protest and the engagement of criminal law was to be very much borne in mind, not only in the liability, but also in the sentencing. So the concern is by saying 10 years maximum sentence, that will suggest a more serious approach to sentencing, but one hopes that won't be the case. Importantly, some attention has been drawn to the fact that the offence now includes a person's act or omission which causes serious distress, serious annoyance, serious inconvenience, or serious loss of immunity. That was in fact a recommendation from the Law Commission. So if you look at the Law Commission paper, which I've put a link to there, it does make the suggestion of serious disruption, serious annoyance and serious inconvenience, but again, not defined anywhere. What's important to note, and sort of a final point on this, is that the Law Commission paper from 2015, when dealing with the defence to public nuisance, which is a reasonable excuse for the act or omission, made it clear that within defence should be included peaceful protest and the rights protected by Article 10 and Article 11. So going back to that balancing act, that has to be at the forefront of the consideration when policing or prosecuting if these offences come into fruition. So public nuisance within the fact sheet, just going back to sort of the explanatory notes and the reasons why the government put forward this proposal in their own words, was it would include now actions such as hanging from a bridge is one of the examples that are used there. But many may remember that in 2013, an Old Bailey jury acquitted two climate activists for hanging from London Bridge, displaying a poster expressing their opinion about the state of emergency we're entering into with climate change. And they were acquitted of the common law offence. The jury did not take the view that that was public nuisance. So I raise that as an example of where the common law and the statute do not marry up, and an indication of where the government's thinking is on public nuisance. So that is a whistle-stop tour of the bill. I will say before we get to sort of questions and answers that all of us have considered the provisions in the bill, and so I think we'll all be answering questions on it. But I want to hand over to Kevin now from NETPOL, so I'll stop sharing my screen.
Thanks, Anna. Just before you hand over to Kevin and I introduce him, a few people in the Q&A have asked about the Protest Handbook. I've posted a link to the Bloomsbury website where it's available. There's also, for attendees of this webinar, a discount code for 20% off, which I think will be posted into the Q&A as well. And it may be that copies are also available through NETPOL as well, but Kevin may be able to help us with that. Maybe my information's out of date. But to introduce Kevin, Kevin was the NETPOL coordinator from 2014 and has become its campaigns coordinator this year when the staff team expanded. He's been active in community-based police monitoring initiatives since 1990. He was the secretary of the United Families and Friends campaign from 1998 to 2009. Has worked for 6 years with anti-fracking groups to challenge oppressive policing and surveillance targeting their protests. He's the co-author of Restricting Rebellion, NETPOL's report on the policing of Extinction Rebellion protests in 2019. And Kevin is going to discuss, I think, primarily the bill that Anna has just outlined. So I'm going to hand over to Kevin now.
Thank you, and thank you to Anna for that kind of whistle-stop tour. I think one of the things that we've been asked a lot over the last week is to explain in really simple terms why it's so important to oppose the bill. And I think all the things that that Anna's outlined, all the things that are wrong with the bill, the sweeping new powers, the fact that was hinted at earlier that this is an act of vengeance against political movements the Home Secretary clearly despises. But the simple answer that we've been giving is that protests, disruptive, annoying, impacting, inconveniencing protests, are the reason why we have many of the freedoms and rights that we now cherish. When we talk about the impact of direct action and civil disobedience now, it's important that we remember that there were movements in the past, like the suffragist movement, that was prepared to break the law. Let's not forget that for large parts of its history, the trade union movement was outlawed and many of its activities were illegal. Let's not forget that more recently, in 1988, opponents of homophobic legislation known as Section 28 were willing to break the law by abseiling into Parliament and occupying a BBC newsroom and were arrested. And I think, bringing this right up to date, let's not forget that it was women from Sisters Uncut who refused to back down to threats from the police, who were prepared to risk arrest to go ahead with Saturday's protest and vigil, and as a result have helped to galvanise public support against the bill and to change Labour's policy on the bill from abstaining on it in a way that wasn't possible when Labour decided to sit on the fence on the Covert Human Intelligence Sources bill. One of the things that in the last few days that we've also been trying to emphasise about this bill is that it's not taking away our right to protest. That's not it. What this crackdown is doing is designed to frighten people off from participating in protests and to make it more difficult for people to organise protests. The reality, though, is that for all of this, groups are still going to protest. There's still going to be groups that will defy the law, and they're still going to protest noisily and disruptively. And that should be absolutely there shouldn't be rocket science. Everybody should be aware of that from looking at what happened with Extinction Rebellion and the need for people to come out and protest in support of Black Lives Matter in the middle of a pandemic. What will happen, though, and this has certainly been outlined by the stuff that Anna's talked about, is that we will see an increase in the number of people who are arrested. We will see an increase in the number of people who are criminalised. Turning specifically to what happens with challenging the bill, the first vote on the second reading is in about half an hour. There's still some way to go before this bill is rushed through, but the government is trying to, and there will be stages where it will be incredibly important for the House of Lords to intervene. But one of the difficulties we face, obviously, is that we have a government with an 80-seat majority that's pushing this legislation as a way of protecting the police. We also have an obvious fundamental problem of trying to argue for the status quo. So it's not good enough to argue that against the bill that the police already have sufficient powers. The police already have far too many powers. The one way that I would agree with Cressida Dick is the Public Order Act is not fit for purpose. It never was fit for purpose. Stopping this bill is about holding back the tide of, yet again, of another piece of criminal justice legislation and there have been many over the last 3 decades. So when we talk about sufficient powers, I mean, did the Public Order Act that exists now restrain the police from shutting down Saturday's vigil? No. Did it prevent police officers from stopping young people walking around London in October 2019 wearing an XR badge from being told that they couldn't cross a bridge? No. Did it stop the police from kettling teenagers, some of them as young as 13, until the early hours of the morning? No. Of course, it's possible when faced with new legislation to push back. And the obvious example of that is when Labour introduced a piece of legislation to essentially to stop one man constantly reminding them of the massive death toll and destruction of their war in Iraq. That was overturned, but we now have a Home Secretary who's now back and willing, as Anna said, to limit protests around Parliament. And Parliament is the one place where people should be able to protest. There is an absolute need for people to be able to shout loudly at the government when the government refuses to listen. So that for us is the reason why Tom, right at the very beginning of this, said this bill needs to be opposed in its entirety. And we entirely do agree. But it is going to be difficult. And actually, we need to be asking for more. We need a fundamental change in the policing of protests in Britain. That can be a starting point from our perspective in talking more broadly about the role of police in society. But one of the things from last week that was kind of sidelined really by the introduction of the bill was another publication, which was a report by the Inspector of Constabulary into the effectiveness of policing of protests, which endorsed many of the decisions that were made by the government in terms of what went into the bill, but also gave a green light to more surveillance on campaigners and a new label for those people who take part in civil disobedience and direct action, which is aggravated activists. That report also recommends essentially the resurrection of the National Public Order Intelligence Unit, a disgraced surveillance unit that was that employed undercover officers like Mark Kennedy. So the reason I mention this is that, you know, changes like that in relation to increased surveillance are coming anyway. They're coming regardless of whether this bill passes or whether it fails. And like many of the measures that are in the bill, that surveillance is framed around the idea that policing can decide when protest rights cease, when they have reached the limits of what we're allowed to do, because protests have made an impact. And particularly, and this is stated in the definition of what an aggravated activist is, when they have an adverse economic impact on businesses. And so much of the bill is framed in the same way. This is about, you know, the impact on an organisation in the vicinity. That has been the reason why the focus of the petition that we launched last week, which, believe me, nobody's more astonished than I am that it currently has over 155,000 signatures. But the focus of that is on the police. For a long time, for years now, in fact, we've been pushing the National Police Chiefs Council to accept that you cannot adequately facilitate protests when public order policing is based on uncertainty, when people have no idea whether, if they go to a protest, how the police will respond, whether they're likely to face arrests, whether they're likely to become the target of intelligence gathering, all of which is, that uncertainty is essentially at the core of the coronavirus regulations, but it's all about disrupting campaigns. It's about discouraging people from supporting and participating in them. And in our view, it's unlawful. There are international human rights obligations on both facilitating and protecting rights to freedom of assembly, both from the Venice Commission and from the United Nations Human Rights Committee. And it's those that we focused on in the new Charter for Freedom of Assembly Rights that we've launched. We've done this and we've written it ourselves in consultation with groups, because over the years, senior officers have refused to produce human rights-based guidance on policing protests. And the one that they did finally produce after pressure from us was so terrible and so fundamentally misunderstood the law that even HM Inspector Constabulary criticised it last week. What we're doing with this charter, and this is in conjunction with the opposition to the bill, is to say you cannot ignore the wider human rights obligations that exist for freedom of assembly. You cannot continue to allow people to have this uncertainty about how you will police demonstrations. We need you to either adopt the very reasonable guidelines that we've produced or explain why you refuse to do so. You can find a copy of that on our website. And the only other thing I would say, because I want to leave us some time for questions, is that if you haven't signed our petition already, please make sure that you do. Thanks.
Thanks, Kevin. So we're running over time, but we don't seem to have been kicked off the Zoom link, so we'll carry on for a little while longer. The Protest Handbook link is available in the chat, including the discount code, and I'm just going to pop it up as well while we deal with answering some of your questions. I'm afraid we've done our best to answer some of them as the webinar has been going along. I'm not sure we're going to be able to get through all of them, but we'll do our best to answer as many as we can. So there's the link and the discount code for the handbook. So in terms of questions, there's a couple of questions or comments to kick off with in relation to the Stansted 15 case. And so Mel, hi Mel, has provided some further context on the Stansted 15 case, which I think is well worth reading. And she sets out there the efforts of the state, just how doggedly determined they were, almost at all costs, to prosecute these 15 heroes. And I think I draw that to your attention because it kind of answers a question which Stephen has posed in relation to the question of necessity and the point in Jones that those issues have to be looked at in the context of a functioning democratic state, and whether or not that could have been questioned or challenged on the appeal. And I think the problem is, obviously, you would be seeking to persuade one arm of the state, the Court of Appeal, which isn't known for its radical decision making, that the UK is no longer a functioning democratic country. That would have been an uphill struggle, I think, putting it mildly. But obviously, it's something which is questioned, and is questioned by activists. And I know it's something that is something that's dealt with when people do give evidence, particularly in XR cases, that they have attempted to raise these issues and just simply got nowhere in the ordinary way of writing to MPs and so on, and that's why further action is required, and that's something that obviously we do hear and is undoubtedly correct. So just dealing with a couple of other questions, I think we've had a couple of questions about the press ID and press at protests, and particularly during the pandemic. Lochlinn, are you able to answer those?
Yeah, so a couple of things. So it's a reasonable excuse to leave the house if you have to work, and if your work requires you to leave the house. Obviously, if you're a journalist or a photojournalist, etc., attending a protest in that capacity is a reasonable excuse. There are very tricky issues when it comes to persuading a police officer that you are a journalist if you don't have an NUJ issued press card, and a lot of bloggers, citizen journalists don't have that, but the press card isn't a silver bullet for the journalist necessarily, but it's also, on the other side of it, not something that is an absolute must from the police side. They should be looking at the situation and seeing whether somebody is acting as a journalist, and when saying they are acting as a journalist, whether there's anything that would persuade them, in fact, this is somebody they consider to be an activist rather than a journalist, and therefore have a different set of considerations involved in them. There have been a number of cases of journalists who've been arrested or fined or so on and so forth over the last few months. There's one, I think, Richard Aitchison, I think his name was, in Kent, in relation to Napier Barracks, who had his house raided by Kent police. They then apologised, and he then got threatened with a fine again the week after. So redress is in the normal way. If you have a fixed penalty notice, you can challenge that. It is possible to make informal representations to the police to say that this has been issued incorrectly, but ultimately the way to challenge that is in the magistrate's court. Arrests where there wasn't actually reasonable grounds to suspect somebody of an offence, and it wasn't necessary to arrest them, give rise to a civil claim in the normal in the normal way. But the underlying thing is that people working as journalists in whichever capacity are working outside and are exempt from the reasonable excuse to leave the house issue. So it shouldn't be a problem, but it often is.
Thanks, Lochlinn. Just to highlight a couple of things from the Q&A, there is a link to the NETPOL petition in there. David Mead has mentioned that there is an open letter for legal academics criticising the bill, urging the government to drop it. It's being circulated. I think if anyone wants to get in contact with David and any academics that want to add their name to it, please do. So there were a couple of questions as well on the way that police have dealt with different actions. So would this be dealt with any differently if it was, would protests be differently dealt with if they were described as vigils? Would that get around these issues? I think that's a question for Lochlinn. And while you're dealing with it, people have raised questions about the way that, for example, the Rangers celebration in Scotland was policed, or some of the other demonstrations have been policed compared to what we saw on Saturday, and whether or not you've got any insight into that.
Okay, so Tony, you might have to mute. Sorry, there's a bit of feedback there. In terms of commemoration, vigil, etc., there is a specific provision. It's an exempt category in relation to gatherings. It's in Schedule 3A, paragraph 6, subparagraph 16. However, there is a limit of 6 people outdoors on that. So, you know, the interesting thing in a way was that both the police and the Home Secretary said that the vigil that went on until 6 o'clock, essentially until the one that had previously been announced, people going to give flowers to stand there, frankly commemorating in the way that the regulations seem to envisage, was fine, despite obviously there being far more than 6 people turning up, you do have a reasonable excuse to leave the house to go, including if your house is in Kensington Palace. So that was all possible in one sense, but it was a bit strange that it sort of, and it creates that confusion for people. Well, if there's a large visual of people going throughout the day and more than 6 people there, why are the police not intervening? Then you have the situation. There is a slight difference. Scotland and England, different laws, different police forces, but this has been a significant problem throughout. Is that there's inconsistent application of the law, and the police not really knowing themselves when they can intervene and when they shouldn't, and seemingly deciding it. Public order commanders on the ground deciding they want to, rather than anything else. So perhaps the police in Scotland decided it wouldn't be worth trying to disperse a group of football fans, whereas they did decide it was worth trying to disperse a group of women, which I think tells you a lot more about the police than anything else. So I get the question, why one rule for one rule for another? But there is no simple answer, because the police themselves wouldn't be able to answer it, because there's an inconsistent approach to these things.
Thanks, Lochlinn. Just very quickly, there's a question on whether we're going to see more prosecutions for public nuisance under the new legislation. And I think one factor which may make it unlikely is that those cases provide the option of going in front of a jury, as opposed to the vast majority of XR prosecutions for breach of Section 14 or obstruction of the highway, which dealt with in the Magistrates' Court, which has the 99% conviction rate. So I think that's one limiting factor which applied to the common law and will apply to the new offence. Owen wanted to come in on the Stansted questions that we covered earlier. Owen?
Just quickly on that. So at trial, the defendants obviously gave a lot of evidence about the futility of alternative means to protect those on the flight. On appeal, the issue about the functioning democratic state was addressed primarily through the lack of available alternative action, because obviously traditional campaigning would fall within alternative action, and the point that was made was really the lack of alternatives is a matter for the jury to assess, and there is quite a bit of case law supporting that. A Canadian case of Latimer the case of Linus, whose 2002 case, which involved someone who claimed they were threatened by a loan shark. In that case, Court of Appeal said the only evidence about the futility of going to the police was the defendant's own assertion, but that was enough to leave it to the jury. This was put before the Court of Appeal, also referenced to the recent FB Afghanistan case where the Court of Appeal said that there was a risk of lack of access to the courts in the immigration system, and the Lord Chief Justice sat on that case. So those matters were all addressed in the written and oral submissions. They didn't make it into the judgment because the Court of Appeal dealt with the point in a very sort of direct way. Just picking up on one of the other questions in the chat from Dave Timms in relation to guidance on nuisance and annoyance within the statutory definition for public nuisance. I think it's illustrative to look at the comments of Lord Justice Laws in Tabernacle, because although the bylaw prohibiting nuisance and annoyance wasn't directly under appeal in the Court of Appeal, the comments he made about rights worth having being unruly things, in my opinion, is directly commenting on provisions such as that. It's worth noting that annoyance is not a word that generally comes in the common law definition of public nuisance. Obviously, nuisance is. Nuisance and annoyance are not matters which the European Court generally use as grounds to justify interference with the right to freedom of expression. The European Court refers to disorder, and generally where it comes to sort of some threshold conditions, the European Court tend to refer to serious disruption or serious disorder as the threshold required. So I think that the proposed definition of public nuisance is a significant weakening of the elements of the offence, and it will be important to interpret those elements in light of the European case law and try and read in as a sort of stronger requirement. That's just what I'm saying on that. Oh, and the other question, there was a question from Gus in relation to chalking in criminal damage cases, and he asked about whether there were any helpful authorities on chalking and referred to the Hardman case. It's important to note damage is always a factual matter in cases Morphetus and Salmon for that. Hardman is a 1986 case, so that's pre-Human Rights Act. And Laporte obviously says that the Human Rights Act was a constitutional shift. So I would have thought that that sort of issue is one that is ripe for looking at in the higher courts as to whether low-level criminal damage ought to be tolerated as a form of freedom of expression.
Thanks, Owen. I think we have gone significantly over time. I'm just to finish, there's one question from Alex who's asked how likely it is that the bill will be dropped. I think, as I said at the start, I don't think it's going to be dropped lightly. I think it's going to be a hard fight. I think the events of this weekend have shown just really what is at stake, the dangers of increasing the power to restrict protest, and we need to galvanise that public awareness and move it forward to make sure that this bill does not ever get onto the statute book. But it's not something that we can afford to be complacent about. This government are determined to quash dissent wherever they see it. They have the numbers in Parliament, unless they can enough of them can be persuaded as to just how illiberal and oppressive these new laws would be, just how much public opposition there is to them, that unless that tank can be turned around, we are going to be fighting these laws for a long time to come in the courts, and trying to overturn them that way. But let's try and cut this off at the knees and make sure that that never ever happens. Can I just thank all of the speakers from this evening, thank everybody who's joined us. I'm sorry we can't get through all of the questions and the interesting discussion that's going on in the Q&A. The video will be available on the Chamber's website tomorrow if anyone wants to revisit any of it. I think you may be emailed a copy and possibly a copy of the Q&A as well, but I'm not sure about that. If you make inquiries with the Garden Court marketing department, they'll be able to assist if you don't get it. But thank you very much for joining us, and we'll leave you now to enjoy the rest of your evening. Thank you very much.